So the Pennsylvania Supreme Court has made a decision on whether an employer can essentially force an immigrant, an illegal immigrant, we think an illegal immigrant, to admit that they are not a legal resident in the United States and are not eligible for workers' compensation benefits. So this decision was just decided on July 21st, 2014, just 7 days ago, by the Pennsylvania Supreme Court. The case is called David Cruz versus Workers' Compensation Appeal Board and the Kennett Square Specialties, and the insurance company in this case is PMA Management. So what the question here is, at least this is the way the court phrased the question, and I think that's what's very important about this decision. The court said they are asked to address the proper allocation of the burden of proof between the employer and the workers' compensation claimant regarding an injured employee's legal eligibility under federal immigration law to obtain suitable employment whenever the employer asks to suspend workers' compensation benefits. So this is really not a question about whether an employee is allowed to receive workers' compensation benefits if they're not a legal resident. The question is, who's got the burden of proof? Who has to prove that the claimant is not a legal resident in the United States of America or in Pennsylvania in order to receive workers' compensation benefits? So that's a really important thing about this case, is you have to understand what they're asking here, and what they're answering is who has to prove that the injured worker is illegal. And I'll give you the short answer. The employer has to prove it. The injured worker doesn't have to do anything. The injured worker does not have to prove that they are a legal resident. They don't have to prove that they are complying with all the federal immigration laws. In other words, the claimant doesn't have to do anything. When the employer is trying to stop workers' compensation benefits, the employer has to prove everything. And in this case, they failed to do so. So there's a few things in here that I want to take a look at that I think is very important. First of all, essentially this worked its way all the way up to the Pennsylvania Supreme Court, from a workers' compensation judge's decision through the Workers' Compensation Appeal Board all the way to the Commonwealth Court. And the Pennsylvania Supreme Court decided, that's why they say we hold, they decided that the Commonwealth Court correctly determined that the employer bore the burden to prove that the loss of earning power was due to the lack of United States citizenship or other legal work authorization in order to obtain a suspension of his workers' compensation benefits. Now that goes even a little deeper. Basically what the court is saying here is that the employer has the burden of proving that the reason the claimant, the injured worker, has a loss of earning power is due to his U.S. citizenship or lack of U.S. citizenship. They also had a little bit of a subholding here, which is actually quite significant. In this case, the claimant, the injured worker, invoked the Fifth Amendment when he testified. He was asked by the employer's attorney, "Are you a legal resident of the United States?" And he took the Fifth. And the appellate court, the Supreme Court and the Commonwealth Court determined that's not enough evidence to prove that the injured worker is not a legal resident. In other words, just by having the claimant take the Fifth, the judge can't say, he took the Fifth and therefore he's illegal. That's not evidence. That's just claimant taking the Fifth. There could be lots of reasons why the claimant doesn't want to testify about what his resident status is. Maybe his lawyer told him not to do that, not to testify about that. Who knows? But that is not what we call in workers' comp substantial evidence. In order for a judge in a workers' compensation case to make a finding of fact, to determine that something is a fact, the sky is blue, for example, there has to be substantial evidence that the sky is blue. There has to be evidence that proves the fact is true or not true. And in this case, the Pennsylvania Supreme Court decided that just because the claimant takes the Fifth when asked about whether he's legal, that's not substantial evidence. The judge cannot rely on that lack of testimony, or the fact that the claimant took the fifth to prove that the claimant is illegal. It doesn't really prove anything. All it proves is the claimant's taken the fifth. So they give you some background on the case. This injury happened in July of 2008. He was working as a truck driver. He felt something snap in his lower back when he was loading some barrels on his truck. He was ordered by his physician to have some limited work activities, bending, stretching, reaching, so forth. Very common in a workers' compensation case with a lower back problem. The employer issued a temporary notice, or what's called a notice of temporary compensation payable. And they started paying the claimant some workers' compensation wage loss benefits until about 60 days later, it appears, when it stopped payment, and they issued a formal denial of comp. So what they did was they picked the case up temporarily, and they paid the claimant some benefits, and then what they did was they stopped the benefits and denied the claim. So the claimant then filed a claim petition. And that's interesting. The way I read this decision is interesting because the claimant in a claim petition has the burden of proof. The claimant has to prove all the elements necessary to sustain his burden of proof, or to prove that he was injured on the job and he's entitled to benefits. So the claim petition is filed. They go through litigation. I'm sure it took a long time. Let's see, it looks like a hearing was held in October of 2008. The employer did some cross-examination. Claimant said he was born in Ecuador. The employer asked when he came to the United States. He said about 10 years previously. And then the claimant's attorney objected to any questions about claimant's citizenship, and the judge overruled the objection, stating that the case law makes citizenship relevant. Okay, so more questions, and asked about a green card, and that's when the claimant, through counsel, invoked his Fifth Amendment right against self-incrimination. So interesting, because you have a claim petition. The employer's trying to find out if the claimant, the injured worker, is a legal resident of the United States of America. Claimant's attorney objects, and then the claimant takes the fifth. Okay. Rather curious way for that to go in, but that's what happened. Maybe it's not so curious. One thing I have to say about workers' compensation cases, they move relatively fast, at least fast for some attorneys. You could have a claim petition filed in, just look at this case. You could have a claim petition filed in September, and then all of a sudden in October, the claimant's already testifying. In a typical non-workers' compensation case, you typically, say a car accident, you typically don't get to question the plaintiff for anywhere from, it could vary, 6 months, a year. In those cases, car accident case, you do paper discovery first, interrogatories, you get all the medical records, you go in and you take the motor vehicle accident victim, you take their deposition, maybe a year down the road, maybe 6 months, maybe longer. Certainly not a month after the complaint is filed. So workers' compensation cases, you tend to get the opportunity, and I always look at it as an opportunity to cross-examine the claimant very quickly. Some judges, not all, but some judges like to take the claimant's testimony at the first hearing. And the first hearing is usually, at least now in 2014, usually held within about a month after the petition is filed and assigned to a judge. So that's an important thing to think about, because you might not have all of the documents that you want when you cross-examine a claimant or when you cross-examine the employer in a workers' compensation case. So something to bear in mind on these cases is that, in this case, they wanted to know if the injured worker, the claimant, was a legal resident in the United States at the first hearing, and he takes the fifth. I would have handled this, and of course, 2020 hindsight here, and it's always a Monday morning quarterbacking situation, but if this was a case that I was handling, I would want to know exactly what documents this claimant gave to the employer when he was hired. You can certainly see that in his personnel file. And I'd want to know exactly how he was able to, first of all, get hired if he was not legal. Did he submit documents that were not accurate? Did he basically fudge his way through the application process in order to become an employee with this company and then sustain a work-related injury? And if that was the case, I'd want to possibly have the employer testify that maybe that's what happened. I don't know. In this case, it doesn't go into that at all. The employer really, I don't think, ever testified in this case, which is important because that's essentially what ended up hanging the employers, that they didn't put their own testimony on. That's very important in a workers' compensation case. You can't rely on the claimant to prove your case if you're the employer. That's a basic tenet that I employ in every workers' compensation case is I'm not going to rely on the claimant to help me prove my case. Sometimes they trip and fall and stumble and they'll hand up a piece of evidence to me that I never expected. But for the most part, a claimant is not going to prove the employer's case. This is a perfect example of it because they took the fifth. So here's one part of the decision, and once again it sort of proves my point. I think this was, what really hung the employer up in this case. It says, the Supreme Court says, ultimately, employer did not provide any evidence of record regarding claimant's legal authorization to work in the United States. Ouch. So the employer is trying to prove the claimant is illegal, crosses the claimant takes the fifth, and then doesn't do anything else. Essentially, he's going to rely on the claimant taking the fifth to try to show that the claimant's not a resident alien. I don't know if I would take that approach, but once again, it's Monday morning quarterbacking on my part, so I'm not going to criticize the employer for that. I would have taken a different approach. So the WCJ issues the decision, finds the claimant's injury was work-related, rendered him disabled, ordered them to pay benefits. But then the WCJ suspended claimant's benefits from the date of claimant's injury based on the finding that the employer has met its burden to establish that the claimant was not a United States citizen and he was not authorized to work in this country. And then they cite the WCJ decision, the judge cites the Reinforced Earth decision from 2002. Now you got to go back a little bit and understand the Reinforced Earth decision. That was the decision that an undocumented worker was not precluded, meaning that's a double negative. Undocumented worker was allowed to receive workers' compensation even if he did not possess the requisite authorization to work under federal immigration law. But the lead opinion also found that an employer could seek to suspend those benefits without having to demonstrate showing job availability under Kaczynski. So really complicated, but I'll try and break it down. So Reinforced Earth said an undocumented worker is able to receive workers' comp. You can't prevent that just because he doesn't possess the requisite authorization to work under federal immigration law. All right? But the employer could suspend the benefits without having to show a job under Kaczynski if the person's illegal. That's really where the nut in this case comes down to, is how do you show that the person is illegal? And the way you do that is through employer testimony. I think the employer has to come in and testify that they have evidence that would get past hearsay showing that the claimant is not a legal resident alien. You might need to bring in someone from the federal government, perhaps, if you could do that. You might get into a burden of proof issue if you just have a letter from immigration control that says the person's not a legal resident. Then you might be able to prove that, but once again, that's something you're going to have to, I would look at in every case. So once again, the Pennsylvania Supreme Court in this Cruz decision says that although the WCJ referenced the reinforced earth, we find it has little application here. Our court did not purport in that decision to relieve an employer when they're trying to stop benefits of the threshold burden of showing factually that the employee's loss of earning power was caused by this lack of legal work authorization. So, and this just dawned on me too. Another way you might be able to, as an employer, prove that an illegal immigrant does not have any earning power is by using a vocational expert. Have the immigrant interviewed by a vocational expert and have that vocational expert testify. I'm a vocational expert. I know what employers have to prove in order to hire someone. This person, I've examined all the documents. He's not a legal resident, and because of that, he doesn't have an earning capacity. That is one way to show, I think, that a claimant in the country illegally without requisite federal authorization does not have an ability to work or get a job. But once again, the PA Supreme Court in this decision in Cruz goes back and said we had no occasion to give an opinion on the question in that case where the employer doesn't produce any evidence. And they actually hint to it too in the form of an affidavit. That's another way. From an official of the Immigration and Naturalization Service establishing the invalidity of employees' work eligibility documentation. So here the PA Supreme Court is really showing us the way. I would think that the proper way to do it is by affidavit from someone in Immigration and Naturalization Service. Now, I've dealt with the federal government on some other issues. I've dealt with the Immigration and Naturalization Service. I wonder if you could even get that document. They have pretty stringent requirements as to what they can testify to and what they can sign affidavits for, but worth a shot. So in any event, reinforced earth, according to the Supreme Court in this decision and the Cruz versus Kennett Square decision, says reinforced earth doesn't say the employer doesn't have to prove anything. Employer still must prove that the claimant is not a legal resident. So then they go more with the claimant appealed the appeal board. They're giving us more of the history. The appeal board said that since the employer provided no independent evidence to support its contention that claimant was an undocumented worker, employer was not relieved of its burden to show claimant's earning power or a job availability. So goes on and on. Once again, that's why it's so important the way they phrase the question as to who had the burden of proof here. More discussion, so on and so forth. I think those are the important parts of this decision. They give a very good analysis of burden of proof. I'll give you the summary. It's the employer's burden of proof. They talk about how to modify benefits and suspend benefits. They talk about this Brem decision. Basically in Brem, the court looked at this whole issue of in a claim petition the claimant has to prove everything, but that doesn't save the employer anything. In this case, they basically tried to punt with claimant's fifth, not enough. On and on we get to the decision at the end here. Accordingly, they affirm the Commonwealth Court. Claimants taking the fifth did not relieve the employer of proving with independent and probative evidence what the claimant's citizenship status and his employment eligibility was. Great decision, I think. I think that was the right call. They should have put the employer on the stand. They could have had a vocational expert testify. They could have had maybe try to subpoena someone to come in from immigration or at least get an affidavit from immigration. But I'm sure if the employer testified, I recall that there is a federal database that employers use to show, if I'm not mistaken, if someone is illegal, and I'm just running this through Google right now. I thought there was a federal database where you could check someone's legal immigration status online, but I could be mistaken. I seem to recall that somewhere. But maybe it's E-Verify. Yeah, here it is right here. This is actually, yeah, here we go. I know the employers I represent use this system. It allows an employer to type in the person's name and social security number and verify. No, I don't want to do a question and answer. So E-Verify is an internet-based system that compares information from the employee's I-9, his employment eligibility verification, to data from the U.S. Department of Homeland Security to confirm employment eligibility. I mean, here's a system right here. I don't know if this was in place when that Cruz decision was working, but here's a system right here that you could easily determine if someone, at least on this system, is able to work. So, great decision. Hope you found this helpful. Of course, if you have any questions, you can always give me a call and I'd be glad to answer them.